So the Supreme Court has today allowed a 14-year-old girl to abort a child after having passed 24 weeks. We have Abantika Ghosh with us. Abantika, a few questions. What has been the legal position so far?
The legal position so far has been that nobody who is more than 20 weeks pregnant can abort. This position, though this is a unique case because this is the first time the Supreme Court has actually allowed a girl to abort beyond 20 weeks, this is not the first time this question has been raised. The question was also raised when a Mumbai couple approached the Bombay High Court in 2008 saying that their unborn child, she was 26 weeks pregnant at that time, I think, and the child had a congenital abnormality and they wanted to abort the baby. The court did not allow, though the woman miscarried a few weeks later. That is where first we started hearing about this discrepancy in the law and medical advancements.
So why 20 weeks? 20 or 24 weeks, biologically as well as legally?
20 weeks dates back to 1971.
Okay.
The ceiling hasn't been revised since then, and that was also when you did not have medical technology like ultrasound, fetal monitors, which could predict a possible congenital abnormality. So and also at that point of time it was thought to be safe. So 20 weeks was the limit, but now doctors are unanimous that 20 to 24 weeks change does not have any implications for the mother's health or mother's health going worse, number one. Number two, also that it is not before 18 weeks that the congenital abnormality is detected, and 20 weeks is too short a time frame for a couple to go through the other tests, explore their options and exhaust them and decide that we want to abort this baby. So 24 weeks is where we are in the process of revising the medical termination of pregnancy law to make it legal for anybody to abort at 24 weeks, up to 24 weeks.
And what stage is this bill at the moment?
It was the Health Ministry had asked for feedback from the people. They have received it. They are drafting it. Also, there are two things I want to add to this. The amendment to the bill is basically designed at improving the service provider base for abortions. By service provider here, I mean qualified doctor, proper hygienic facility. So which is why it also allows Unani, Siddha, Ayurveda doctors to abort fetuses medically, not surgically. Where this law actually moves forward and where this Supreme Court judgment also moves forward is that it looks beyond a woman as just a body bearing a child and looks at her as a human being whose mental health is one of the considerations in granting her leave to abort or not abort. It's not just about whether aborting the baby will be good for her physically, but the fact that her mental health may be affected by not aborting the baby is accepted as a ground in the proposed amended law, which is also what essentially the Supreme Court judgment also has done.
Okay. One thing, does this become a precedent?
No, this particular judgment is for only this case. But in any case, we are in the process of amending. Before that amendment, it will have to be on a case-by-case basis. People will have to approach the courts and get a favourable judgment or otherwise.